Yes, I'll speak today about how immigration law gives extra protection for victims of domestic violence. I'll speak if you if you are eligible for victim of domestic violence concession, then you will get directly indefinite leave to remain in the UK. I'll speak about what step you should take, how you can make the application for indefinite leave to remain if you become victim of domestic violence. Yes, my name is Suhal Ahmed. I'm an immigration lawyer in here. If you have any question, please feel free to make a comment below my live video, or you can call me at the number appear to be in the screen. If anyone who become victim of domestic violence, and if you are eligible, I'll discuss the eligibility requirement. But first, I'll introduce and I'll give information what is actually a victim of domestic violence, because there's a misconception that uh, uh, some people believe that only women can be victim of domestic violence. But from my experience as a lawyer, I found many men also become victim of domestic violence. So, irrespective of gender, if you have become victim of domestic violence, you should take immediate step for your safety, for your protection. And immigration law take very strict rules and strict position and give extra protection for the victim of domestic violence. You will get directly indefinite leave to remain access to public fund within 48 hours if you can make right application and take appropriate step on right time. So first, let me explain what is a victim of domestic violence. The definition of victim of domestic violence is very wide. It is it include very basically domestic abuse is any kinds of or any incident pattern of controlling or threatening behavior, violence, abuse between age of 16 or over who are being intimate partner or family member, or regardless of gender or sexuality. This can be physical, emotional, psychological, sexual, or financial. So the definition is very wide. So if you become victim of domestic violence, you should make appropriate step in due course. Because if you cannot take appropriate step, you will lose the protection of immigration law and as well as other law. This is not today discussion is not a family law. I'll speak about immigration law basically. So who are basically eligible for domestic violence. So the requirement of immigration law is, requirement of indefinite leave to remain is your last leave to remain must be under Appendix FM. So if you come in the UK as a spouse or as a family member of any British citizen or settled person in the UK, and if your relationship break down because of domestic violence, you can apply directly indefinitely to remain. So that is the indefinite eligibility requirement. So you have to your last leave to remain must be, or leave to enter must be under Appendix FM. Your partner or family member, immediate family member to whom you become victim must be either a British citizen or settled in the UK, and your relationship has been breakdown because of your domestic violence. So these are the eligibility requirement. Once you satisfy this requirement, and then now I'll speak what step you should take. So if you become a victim of domestic violence, first step you should immediately apply to the Home Office, which is domestic violence concession form application. Generally, when someone become a domestic victim of domestic violence, he should immediately make a first emergency application, and the Home Office will issue a visa for 3 months. Normally, when someone become victim, if you want to make an application for directly ILR, it because this will put you in bit longer process. It will take 6 month time for a decision. You don't have money, you don't have access to public funds, you don't have accommodation, and this will put you very difficult situation. And to save from this difficulty, the Home Office introduced emergency help, that is a victim of domestic violence concession application. So you need to make this application immediately, and within 48 hours you will get a decision from the Home Office. The application form is DDC application, domestic violence concession application form. The form available in Home Office website. You need to fill up this form and you need to send it to the Liverpool Home Office there. And there is a duty officer over there. When he or she get any form of application, immediately, without verify the details, immediately within 48 hours, as soon as possible, the duty officer will issue a BRP for 3 months. This BRP or visa will allow you to access to public fund, accommodation from local authority, help from charity. So you get 3 times a time to breathe. So within this 3 months, you will make your final indefinite leave to remain application to the Home Office. You don't need to pay any Home Office fee, because generally ILR fee is more than £2300. If you apply for ILR on the basis of your domestic balance, you don't need to pay actually the Home Office fee. So you need to make the correct application immediately. You will have access to public funds. So first step is to apply domestic violence concession application. You will get 3 month visa with access to public funds immediately within 48 hours. And then the next step is you need to make an application for indefinite leave to remain. Indefinite leave to remain, you don't need to satisfy all these requirements, that is life in the UK test. You don't need to pay fees, you don't need to satisfy the English language requirement. You just need to make the application form without paying any Home Office fee. Also, you will get legal aid if you cannot pay the solicitor or legal fee. That's why I said the immigration law give extra protection for victim of domestic violence. Viewers, Sohail Ahmed here. If you have any question, please leave the comment. I'll give you answer. I'll back here again discuss about the same route. I'll take some question from the Facebook. Jignesh Raman, you asked me, EU settlement status, 5-year settlement status coming, biometric card apply after how long coming? EU settlement status, 5-year settled status coming, biometric card. I don't. It's not clear to me, but I'll give you answer both. What I understand first. Probably you ask me how long it take for EU settlement scheme to get my biometric card. Generally, within 1 week, you should get your EU settlement decision, EU settled status decision, and after 1 week, you will get your BRP card. For after within 1 week or 12 days, you should get your BRP card. However, first, if you are non-EU nationals, and if you cannot provide all the necessary document, all the supporting document with your application, that case the decision will delay. So you will get maybe 1 or 2 months later your decision. But however, you can contact to the Home Office. There is a contact number, which is EU Regulation Contact Center. You can call them, started from 0300. If you call them, they will give you the details information. The second issue is how long take the biometric. Generally within 12 days, but BRP card arrived should come from the decision of Home Office. However, in EU settlement scheme, I saw that issue. Those who have a biometric residence permit is not expired. For example, you have EU residence permit, or you have EU family member permit, or you have permanent residence card. If you make an application under EU settlement scheme, Home Office will not issue any new BRP until your BRP expires. In that case, you'll be required to wait Once your BRP will expire, you will automatically get a BRP. You don't need to do anything. Home Office have that system. Automatically, before expire, you will get your BRP card. In case if you don't get it, contact to the Home Office. Again, EU Resolution Center, you can give a call, a very good service. Most of the time they pick up, not like other Home Office number, they will give your answer. Thank you very much for your question. Next question. Ramin Darrell, is settled status same as ILR? Yes, settled status is same as indefinite leave to remain. So there is not much difference between them. The difference is only ILR, they granted under immigration rules, and for settled status is granted under EU settlement scheme. So requirement is different, but legal position after you get the ILR is same. Then again, Ramin Duran Kali, you asked me, is settled status same as indefinite leave to remain? Yes, that's I gave the answer. Then you asked me, what is going to happen with those who have pre-settled status? Pre-settled status basically for those people, whether you are EU nationals or non-EU nationals. If you live in the UK, if you come from the UK, this is a big discussion, but I'll give you an answer after a short break. So, Brother Ramin asked me, what is going to happen with those who have pre-settled status? Now, pre-settled status is issued for those EU nationals or non-EU family member who is in the UK, but they are living less than 5 years. If you want to continue to live in the UK after Brexit, means after 31st December 2020 or 1st June 2021, you must apply for pre-settled status. So once you secure the pre-settled status, then after 5 years of residence in the UK, you'll be eligible for EU settled status. That means you will get after indefinite leave to remain after 5 years. So this is what you will get if you have the ILR. Now the requirement is for pre-settled status, that is, you must be a EU national or EU family member. You have to be a qualified person. Pre-settled status you can apply from inside the UK or from outside the UK. Either way, if you apply from outside the UK, it has to be pre-settled status for leave to enter. If you apply from inside the UK, it will be pre-settled status for leave to remain. Now, it is very simple application. However, the effect or impact will be very big. Those who will not have a pre-settled status, if you are EU nationals or non-EU family member, if you don't make this application for pre-settled status after Brexit, you will face very difficult time. From the last week, I saw an update in a website that many people, even not familiar EU people, not even then bother or care about the EU settlement application, but I will advise you, I will invite you, request to make that application, because if you don't make the application, you will face very difficult time, because after Brexit, you will not able to do job in the UK, you will not able to apply for any kinds of benefit, welfare benefit, you will not able to get an accommodation or tenancy agreement. Bank will not offer you any bank account. So whatever you want to do, if you want to continue to live in the UK, then you must apply for EU settle, either pre-settled or settled status. This is a very straightforward application. That's why I said it is important for you to make the application. You can also invite your family member to bring them from outside the UK, outside the European Union. If any EU nationals want to bring your family member from Africa or Pakistan, Asia, Bangladesh, you can just invite them. under the pre-settled status. Family member including your children, wife, your parents, dependent parents, extended family member as well, which is very wide. Anyone who is financially dependent on you, any relative, they are extended family member. Under the EU settlement scheme as well as under EU regulation, you can invite them to come to the UK. Now, which route you should, whether you should go to EU settlement scheme or go to EU law, that depend. But I'll advise always to make an application under EU settlement scheme, because if you make an application under EU law, EU regulation 2016, you will get visa less than 1 year. Thank you very much for your question. Next question. Al-Cloth. Assalamu alaikum, Sarah. Wa alaikum salam. If you remember in your last streaming, if you remember in your last stream, I have been advised to tell Home Office by writing a letter about getting child benefit, as visa condition is no recourse to public fund. Could you please advise me what to write and what would be the better heading? I have called HMRC to stop the benefits. My application for FLR for 10 years with extension made in June. Okay, so basically what I said, I remember you that you received public fund, what is a child benefit, what actually not. You're not entitled to get any kinds of benefit because your visa condition is not equal to public fund. If you receive, then it will be a breach of immigration rules or breach of your visa condition, and in that case Home Office may refuse your application in future for a small amount of money. I understand you did a mistake, so I told you that stop the benefit, child benefit, and tell the HMRC that whatever benefit they gave you, this was a mistake, you want to refund this. So I ask you that refund all the money, and then you'll write a Home Office that by mistake or by misunderstanding, I have received some child benefit from the HMRC. I had, it was a mistake, and then seek an apology and tell them that I have sent all the benefit back to the HMRC, whatever they paid, and give a proof of your return. So you write the you'll refund it to the HMRC, seek a letter, ask a HMRC letter about the confirmation that they received all this money what they paid you, and with this letter and your letter, what you'll write, a cover letter, send it to the Home Office explaining that this was a mistake I have received mistakenly or unintentionally from HMRC. Then when I realized that this was I'm not entitled to claim child benefit, I return all the money what they paid to me to the HMRC. So write a letter, what I said, and as well you take some form of letter from the HMRC about the confirmation that you paid off. If you make an installment payment even, that will be sufficient. Just take a letter from the HMRC, or maybe HMRC already wrote a letter, send it to the HMRC. So I hope it will not be a problem. Thank you, Ramin. Thank you. Wasim Kalor, can I ask a question about Tier 4 visa extension? Please feel free to ask, brother. Dean Ryan, you asked me how much money quality 18,600 requirement. How much month? 6 months. I'll tell you 6 months and 1 year. I think my camera. So, Diana, you asked me spouse visa. Yes. If you are on salarized employment, if you are in employment, you will you need to earn 18,600 pounds, and you need to provide evidence of last 6 months. So if you can provide, if you are on salarized employment, then you need to provide 6 month payslip that you earn 18,600 pounds. If you are self-employed, then you need to give 1 year. So if you are 1 year, if you are self-employed, you need to give 1 year income details. That is how much you earn. It has to be more than 18,600 pounds or 18,600. You need to provide evidence of if you are a salarized, then you need to pay your last 6 month pay slip, last 6 month bank statement, and a letter from your employer explaining how much you earn per month and how much you earn, how much your salary. That what all details. That's what you need to send. If you are self-employed, you need to provide a letter from your accountant, the summary of your return, the calculation from HMRC, and a calculation from your accountant. That is what you need to do. Also, you need to give 1 year bank statement. So if you are a self-employed, you need 1 year income details. If you are a salaried, you need only 6 months. This is a discrimination actually. Brother Wasim, you asked me in Tier 4 visa extension after 5th October, the applicant don't need financial document bank statement. Is it true? This is not true. This is a false information. Tier 4 student, 5th October a change is coming. The whole change is from 5th of October. If any international student come in the UK, please note from 4th of October, the new immigration rules, all the European student or non-EU student will be subject to same immigration rules. So if any international student want to come to the UK, then after complete their study, they will able to get 2 years work permit. That's what new immigration rules coming from 5th of October. But there is nothing about that. You don't need to any bank document. This is incorrect information. All the requirement is same. You need to achieve 40 points for under tier 4 student visa. 30 points will come from your cost letter and 10 points will come from your bank document. That is your maintenance. I hope you got your question. Diana, you asked me public funds. If you earn £18,600, you will not get public funds. And public funds will not counted as income if you are required to show £18,600. However, again, universal credit. However, the difference is what you mentioned, PIP, that make me different, and the law considered personal independent is differently. So £18,600 is the basic standard requirement, but there is an exception. The exception is because if any UK nationals or settled person want to bring their spouse from outside the UK, the standard requirement is £18,600. I explained already what you have to show if you are a salarized employment. If you are on self-employed, then I said what you need to do. But the exception is if you are in receipt of personal independent payment, which is basically is to be a disability benefit. In that case, you don't need to show that you earn £18,600. The government home office is show their sympathy for those people who need help, because a person who is disabled, who is receipt of personal independent payment, will not able to work. Accordingly, they give an exemption for those people who are in receipt of personal independent payment. They don't need to satisfy the financial requirement to bring their spouse from overseas. However, they have to satisfy one requirement, that is in terms of financial requirement, that is whatever the income they received, personal independent payment, after pay all the outgoings of their household, there must be same amount of money left in the account, or the same amount of money what someone could get if someone in job seeker allowance. So if you get £1,000 PIP and if you spend £1,000 every month, this will not satisfy the requirement. So if you get £1,000, there must be that amount of money left in every month or every week what you could get if you are on job seeker allowance. Currently I think maybe I think so far I remember is 72 pound job seeker allowance. So whatever you receive weekly basis, after spend you must left some amount of money what could be the amount of job seeker allowance. If you satisfy this small little requirement, you can bring your spouse from overseas, or if you want to apply from UK, if someone here, you can apply for leave to remain as well. Thank you very much, Diana, for your question. Jarul Jarmal Jar. Hi, brother. Can someone on tier 2 visa start its own business, or if someone with startup visa can work for another company? Tier 2 visa, if you on ICT visa, there is a cooling off period. I want to give this update. From next post-Brexit immigration plan, they remove the cooling off period, which is 12 months. So this is a good news for the people who basically in the UK tier 2, because if you want to switch any other visa category, you have to go back to your home country and then you stay 1 year, and after that you can come back again. But these rules will be removed from post Brexit immigration plan new point based system. You ask me that can I start a visa or start a business? Yes, you can do. This is the only exception. You can do it. Next question. Wasim Kakor. As I have to apply from inside. I don't know why your answer, brother. If you ask me before, I'll back again. Now it's 70 point, brother, as per government website. Thank you very much for your information. Shiban Yunis, dear sir, is any news about wrong date of birth but UK Turkey? If you do a mistake in your application, when you fill up the form, if you do any mistake, for example, in terms of your date of birth or your spelling or address, and you submit the application, because after you submit, you cannot change anything. In that case, what you can do, you can you cannot amend the application, but when you submit all the supporting document, you should prepare a statutory declaration in the form of statutory declaration and tell what mistake you did in which section and what is the correct information. So if you give a statutory declaration, or at least if you write a cover letter which you explain what mistake you did and what is the correct information, then the caseworker will change the details in the system and will take your statutory declaration note in their system. So that's what you should do. Diana, what if my father-in-law pay everything beside grocery? Okay, third-party support is not available for if someone pay your maintenance or something like that. But what third-party support is available, generally I said that financial requirement at 3,600 pound. However, if you have saving above 16,000 pound, that will also help you to satisfy the requirement, financial requirement. So in average, if you have saving around 62 or 64,000 pounds, then you don't need to earn any money. Or if you earn some money, but the shortage one, you can, if you have any saving, that will cover your financial requirement. So third party can transfer and help you in terms of saving, that will satisfy and can help you. So this is how it works. I think you need to look at it again, and I think I don't know your, because you asked me question, I understand, but what will be the best route? You can speak to a solicitor directly with all your paperwork, especially take your personal independent payment from DWP, take your bank statement, and what support you can available. For example, in accommodation, if someone offer you an accommodation, that if your partner come from in the UK, then someone will can offer you accommodation. That help can be from third party. So that's what all about it. Thank you, Dana, for your question. Next question. I'll cloth again. Thank you, sir. You always explain me very well. Thank you. Thank you very much. I've called HMRC. The lady said someone from the relevant department will contact me. I'm waiting since. Meantime, she just suspended the benefit. Shall I wait for their response or wrote to Home Office straight away? I'm afraid if Home Office already made a decision. Okay, send an email, and I think you should you should write to the Home Office straight away. You shouldn't wait. Make a write a letter to the Home Office. Explain that I'm waiting for a confirmation from the Home Office. So from the HMRC, because if they make a decision, it will be an issue. So thank you very much, Alcloth. But again, chase the HMRC, send them an email, though I hopefully you will get something. Shell and Budge, thank you very much to come back again. I lost a long time, haven't seen. I'll come back again to. Right, so back to question again. But you asked me, my from India, she has 4-tier visa in expiring on January 2021. She doing she do product manufacturer, what visa she have to apply and when she can apply. I don't understand for your question. Please, if you write clearly, I'll give your answer. Next question, Ahmed Patel. Sir, when is PSW visa start from and more information about please? PSW visa will start from 5th of October. So this is not a PSW visa. This is a student visa. So if any international student, whether from Pakistan, Bangladesh, India, Ghana, Nigeria, Arab, from Spain, Netherlands, French, any international student, whether Europe or non-Europe, if anyone come to the UK, complete a course, and then the student will get 2 years post-study work permit. Within these 2 years, the candidate can work full-time, can do business, and after the 2 years, if candidate get any work permit, the candidate can switch to any other general work permit, for example, tier 2 general work permit. So this is what the new rules coming from 5th of October. Thank you very much. Another friend of mine, she got settled status, an Indian passport holder. Does she need to apply visa again? No, if she got settled status, she doesn't need to apply any visa again. She can apply for British passport after 1 year, but she need to satisfy, not British, excuse me, she can apply for naturalization after 1 year to become a British citizen. This is the correct answer. So she doesn't need to apply for any settled status. What she needs to apply is for naturalization. She will be required to satisfy all the requirement. That is, she need to pass English language test B1. She will be required to pass life in the UK, because when she gets settled status, she didn't satisfy this requirement. Because normally if anyone apply for indefinite leave to remain, she will be required to pass B1 test and life in the UK. However, under EU settlement scheme, non-EU citizen or EU citizen doesn't need to satisfy this requirement. Accordingly, she didn't satisfy the requirement. However, when she will apply for naturalization to become a British citizen, she will be required to submit pass life in the UK and B1 certificate. Shivna Yunis, thank you for helping everyone. Thank you. Thank you too for your nice comment. Thanks a lot for your help. Thanks everyone. Take care, everyone. Please share my video or invite your community to subscribe me because I came here live to help the community. Just if you have any legal question about it regard to immigration or family employment, you can ask me. Either you can write a comment below or you can call me to the number appear at a screen. I'll end my live session today here. All of you have a very good night.